Okay, well, people are still joining. I think now would be a good time to make a start, to make full use of our hour. I'd like to welcome everyone to this, the next, in our new faculty webinar series, which seeks to bring together all members of the Maryland Carey Law community, students, alumni, faculty, and staff, and to connect everyone to the broader intellectual life of the law school. Before we begin today, our next event in the series will be on Wednesday, October 7 at noon, and will feature a preview of the upcoming Supreme Court term. So please put that on your calendars. That promises to be a terrific event as well. But turning to our webinar this afternoon, I'll be moderating this conversation. And once our two speakers have made their remarks, we will have some time for question and answer as usual. So please put your questions in the chat, and I will be asking the questions as they come up in the chat to our two speakers. Okay, so turning to today's topic, there are really two important events that both occurred this year that provide both the backdrop and the context for this conversation. The first is, of course, the 100th anniversary of the 19th Amendment, which was ratified on 18th of August 1920 and officially became part of the US Constitution on the 26th of August 1920. The text, again, of the 19th Amendment, for those unfamiliar: the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. And then a further clause: Congress shall have power to enforce this article by appropriate legislation. The second event was the 150th anniversary of the 15th Amendment, which was ratified on the 3rd of February 1870 and became part of the Constitution on the 30th of March 1870. And of course, as many here will know, the text is strikingly similar. The right of citizens of the United States to vote shall not be denied or abridged again by the United States or by any state on account, this time, of race, color, or previous condition of servitude. And that clause is, of course, followed again by a provision giving Congress the power to enforce the article by legislation. It's the complicated story and legacy of these two amendments and how their intertwined histories inform the present moment that are the subject of our conversation in this webinar. They're also the subject of the important recent scholarship of our two speakers, who I'd like to introduce. First, Professor Taunya Banks, the Jacob A. France Professor of Equality Jurisprudence, who has a forthcoming article titled First Class Citizenship, the Broken Promise of the 15th and 19th Amendments, which explores the complexity and unfinished business of struggles at the intersection of race and gender for full citizenship in the United States. And second, Professor Paula Monopoli, the Sol and Carlin Hubert Professor of Law, and of course the founding director of our wonderful Women, Leadership and Equality program, who recently published with Oxford University Press her remarkable new book, Constitutional Orphan, Gender Equality and the 19th Amendment. Professor Monopoli's book explores the meaning and scope of the 19th Amendment, particularly in the decade following its ratification, and tells the story of its journey through both the federal and state courts, as well as the fate of enforcement legislation in Congress. Now, what I think is most striking about the book is that it presents us simultaneously with a compelling constitutional argument, as well as with a puzzle. The argument is that the passage of the 19th Amendment represented an important moment in American constitutional history that held the promise of significant change in the political, civil, and social status of women. The puzzle, however, is that what emerged from the decade of contestation following ratification was, according to Professor Monopoli, a thin rather than robust conception of constitutional meaning of the 19th Amendment. So the puzzle that presents us, and the question we're going to be discussing today, is why was the impact of the 19th Amendment on women's equal citizenship so limited, and how was that impact shaped by the intersection of questions of race, gender, and class, which I think are really quite fascinating questions. So to begin our exploration of this history and these questions, I would like to ask Professor Banks to tell us first a bit about the period before ratification of the 19th Amendment in 1920, and how the really complex history of earlier struggles and movements, both prior to and following ratification of the 15th Amendment in 1870, both relate to and are connected to the story that Professor Monopoli is telling in her book about the ratification of the 19th 50 years later. So Professor Banks.
Thank you, Dean Danchin. Most historians cite the 1848 Seneca Falls Women's Rights Conference as marking the beginning of the women's suffrage movement. With the exception of abolitionist Frederick Douglass, the convention was all white. But Douglass's presence at the convention was fitting. Despite sexism within the abolitionist community, the movement, Douglass openly supported women's suffrage. Further, in many respects, the 19th century goals of the suffrage and the abolition movements were similar. Both movements wanted equality, including political rights like voting, jury service, and office holding. Political rights means a seat at the table, which was considered the key to winning lasting equality. If you were there when the decisions were made, you could make sure that your interests were protected. A few scholars argue that the alliance between abolitionists and white women was more than one of mere political convenience. And they suggest that this alliance represented a shared conceptual vision as well. It fused the principles of the American revolution's concern with representation with the radical egalitarianism of the abolitionist movement. Except for Sojourner Truth, most early African-American suffragists like Sarah Redmond and the Fortin sisters were educated, freeborn Northerners. They joined white women suffragists like Susan B. Anthony and Lucretia Mott in the push for universal suffrage, suffrage for all, men and women. Unfortunately, in the telling of the 19th Amendment ratification story, the work of Black women has been erased or virtually erased until recently, in large part because it was written by some of the white feminists, particularly Elizabeth Cady Stanton. So too has the role that race played in the quest for women's suffrage. So, I'm going to talk a little bit about that briefly. This coalition between the women's suffrage movement and the abolitionists lasted through the Civil War, but it fell apart during the debates over the content of the 14th and the 15th Amendments. Some suffragists objected to the inclusion of male in Section 2 of the 14th Amendment, which deals with the apportionment of representation, and that was conditioned on the protection or the protection of the right to vote for male inhabitants as opposed to all inhabitants. But it was really the 15th Amendment where there was a real push for universal suffrage that caused the fracture. And when it became clear that the amendment, although it reads gender neutral, was in fact designed to enfranchise only Black men, the women's movement split. And it was the end of the National Women's, the American Equal Rights Association. And so these two divisions, which I think are probably represented even in the women's movement today, were Susan Anthony and Cady Stanton formed the National Women's Suffrage Association. And these groups were hardliners. They were for the women's suffrage, and they wanted women's suffrage even at the expense of Black male suffrage. The American the titles always get me. The American Women's Suffrage Association was headed by Lucy Stone, who was much more supportive of universal suffrage, including the 15th Amendment. And as this split was occurring, the disenfranchisement of Black men in the South was occurring, and it was brought about in large part due to violence, and then later due to so-called legal mechanisms like literacy test, understanding test, and poll tax. And at the same time, with the end of Reconstruction, you have the rise of this ideology of white supremacy as reflected in Jim Crow laws and practices throughout the country. And increasingly, as this occurred, Southern women gained more influence in the movement. But there wasn't just Southern women. The effect was that, after Reconstruction, Black women were largely excluded a voice in national organizations, and they, in point of fact, in Southern states were excluded from the local organizations altogether. So they had no choice. They had to start their own organizations. And in doing so, you sort of see the difference in the goals. The goals were multiple. One was to try and recover or thwart the disenfranchisement of Black men in the South, while at the same time supporting women's suffrage. And there were some social welfare and educational interest also. I mean, it was commonly called racial uplift, and uplifting the race as a whole. In 1890, the two branches of the women's suffrage movement merged again into the National American Women's Suffrage Association. And the goal of this organization was a constitutional amendment, extending the franchise to women. And one of the things that's kind of sad about this is that some of the women in the movement were still rankled by the fact that Black men got the vote before. And they were also somewhat elitist. And so some people within the movement wanted to push for what they call educated suffrage, which would limit the vote to women who could read and write English. I believe, and I'm sure this is true, that it was the lack of socioeconomic diversity as well as racial diversity within leadership ranks that caused a resolution to be passed in 1903 at the National Convention, noting that there were more white native-born women who could read and write than all the Black and foreign-born voters combined. So that by enfranchising women, namely white native-born women, they would settle, I'm quoting here, the vexed question of rule by literacy, whether homegrown or benign. And so there was a sentiment within some of the movement that this should be for white women's suffrage. There was even an attempt during the debates to go and insert white in front of women in the 19th Amendment, but it was defeated. Nevertheless, there was an understanding among the white suffragists as well as the members of Congress that enfranchising women under the 19th would largely exclude Black women, especially Black women in the South. But also there was the sort of the disregard for the voting rights or potential voting rights of Black women also had a terrible effect on poor Southern white women who were equally disadvantaged by the poll tax and literacy and understanding requirements. And so from the 1890s to the time of ratification, Black and white women continued to push for suffrage, although in several respects on separate tracks. But by the end of the 19th century, you had a new generation of African-American women, people like Mary Church Terrell, Frances Harper, Nanny Burroughs, and others, Ida B. Wells, who assumed leadership roles, either as activists or in the Black women's club movement. And these women sort of clearly articulated the desire to continue pushing for suffrage, even though they knew that many Black women would not be able to exercise it, because the view was if they could secure women's suffrage in northern states, that their numbers with Black men could help them recover or restore the vote to Blacks in the South. And in a forthcoming article in Georgetown Law Review, legal scholars Kamir Gear-Rich and Catherine Powell argue that Black women's combined demand for Black women's rights and civil rights made their movement distinctive. And Johns Hopkins historian Martha Jones writes that in the late 19th and early 20th century, one might argue there were two separate women's movements, with Black women organizing separately, both out of necessity in light of segregation and out of a sense that their goals were different, although overlapping with the goals of white women.
Terrific, thank you. A lot for us to think about there. So let me turn now to Constitutional Orphan, which, as I say, explores the meaning and scope of the 19th Amendment in this period after 1920. So the 10 years following the period that Professor Banks has just described for us. And in the book, Professor Monopoli, you discuss three main areas of constitutional import that you consider. The first being federalism and the role of the national government in state issues, such as the general taxing power, voter eligibility, and also political rights. The two that you discuss in particular are juror eligibility and the right to hold public office. So a whole set of issues around federalism. Secondly, the scope of women's citizenship under the federal constitution and the concerns there at the time about expanding women's political power. And thirdly, the sort of deeper subtext of the book, the constitutional meaning of gender equality under the constitutional framework, and the tensions that we still, of course, see today between formal and substantive views of equality on issues such as wages and legislation. So if I could turn to you then, can you give us a sense of this history, an overview of this period after 1920 in these different areas of constitutional contestation, as you explore them in the book and how they connect to this longer story that Professor Banks has presented to us?
I'd be happy to. Thank you, Peter. And I just want to reiterate that this story is a complicated and intersectional legacy, as Professor Banks has laid out for us, in terms of remembering these two anniversaries and commemorating them. I think the first point I want to make is that as of 1920, for example, Native American women were not citizens and thus could not vote. So Native Americans did not become citizens until federal legislation was passed in 1924. So we talk about the right to vote, but really in essence, there were a number of women who were not covered by the 19th Amendment. And for example, Asian immigrant women could not be naturalized citizens until the late 1940s and 50s. And again, took federal legislation. And of course, as Professor Banks has pointed out, Black women and Latina women in different parts of the country were de facto disenfranchised in many places, much as Black men had been after the 15th Amendment, especially in southern states. So those 3 points that you make about federalism, the scope of women's citizenship, and the constitutional definition of equality, I just make a couple of points about each one, and then we can talk some more about them in our colloquy. But the first is the intersection of race and federalism. Again, as Professor Banks has pointed out, the voting amendments, the 15th being our sort of first voting amendment to add to the polity, to add a new group to the group that governs, was essentially all in the minds of Congress when they were passing the 19th Amendment. So you get a lot of historians who will just say to you, you know, if you want to understand the 19th, and I am grateful to Professor Banks for sharing scholarship with me when I started this project, people like Rosalind Terburg Penn, for example, You need to understand that the 15th was still in the minds of Congress when they were enacting the 19th Amendment to a very large degree. So federalism is implicated in the 19th because you've got essentially the issue here of states having the authority generally under our Constitution to define who's eligible to vote. And anytime Congress steps in, 15th Amendment, 19th Amendment, later on, we've got some other amendments, 26th Amendment, and adds to the polity, right? It is stepping into that territory. So you've got these battles about those elusive lines between states and the federal government here. So the 19th, again, much like the 15th, implicated that elusive boundary line. Where do we sort of draw that line? And it was lawyers like William Marbury here in Baltimore who made arguments that states' rights, local governance, right, should take priority, and that the 19th Amendment was essentially such a contravention of the original compact between the states and the national government that it was an unconstitutional constitutional amendment. Now, that argument lost, and in Lesser versus Garnett, the United States Supreme Court said, no, it's a valid, if the 15th is valid, the 19th is valid, right? So race and federalism were also implicated in the whole issue of enforcement legislation. So after the 19th is ratified, there's a presidential election, and that election in November 1920 resulted in actually a number of women not being allowed to vote because registration deadlines had passed before the amendment was ratified. Especially in southern states, a large number of women were not allowed to vote. And that sort of created an impetus for the white suffrage groups like the National Women's Party, which was a militant offshoot of NASA that Professor Banks had talked about, to get their congressmen to put enforcement legislation. We think of civil rights legislation, right, as kind of emanating from the 14th and 15th Amendment under Section 2 of the 15th, for example. There was enforcement legislation, and similar legislation was put in the hopper in Congress in December 1920. The other thing that happened in that November election was that African-American women were turned away at the polls in enormous numbers, right? Using the same devices that had been used to deprive African-American men of the right to vote, literacy tests, it's just basic intimidation, being forced to stand in long lines when one tried to register. So those African-American suffragists that Professor Banks was talking about, and that newer generation, so Mary Church Terrell, for example, was part of the National Women's Party. They were members of the National Women's Party, although they were marginalized, as Professor Banks had talked about. But in fact, they pushed hard and wanted to introduce a resolution at the National Women's Party convention, which happened after the enforcement legislation was put in, for a congressional investigation of the deprivation of the vote in the South for African-American women. And they had allies in that suffrage movement, people like Florence Kelley and Mary White Ovington, who actually tried to help them put a resolution on the floor that would call for a federal investigation. That effort failed. Alice Paul, who was the head of the National Women's Party, separated artificially race and sex, used it as a sort of strategic move to avoid the question on the floor. And that was a misconstitutional moment, as we had mentioned before. And again, enforcement legislation, the lack thereof, comes to haunt the 19th in terms of its efficacy and its utility. And I would argue it still haunts us today because we don't have an Equal Rights Amendment yet ratified. So, and I'm happy to talk some more about that story too. So race plays a central role in the truncating of the 19th Amendment in this way. And the second point that you make, which is gender in the scope of women's citizenship, in fact, the states then had to deal with this 19th Amendment. And there was a consensus in state courts about the fact that it was self-executing, as the 15th had been. And in fact, it struck the word, male from a lot of state laws, state constitutional provisions, which said only men could vote. And everyone sort of, the court seemed to have a consensus about self-execution, but they didn't agree on how far that self-execution went. What was the scope of this self-execution? Was it just voting, or was it some of the other political rights? Things like jury service, things like holding public office. And there was a split among states. So they spent those 10 years in this sort of contested environment, deciding what the 19th meant in terms of how broad a citizenship were women going to get from this amendment. And what emerged at the end, and I would argue again, in part because they didn't have guidance on the part of Congress in the form of some sort of legislation, right? And it didn't give them any constraints. So you end up with a divided set of opinions in state courts about the meaning of the 19th Amendment. And in fact, by the end of the decade, you've got a state court in Massachusetts saying, well, it doesn't mean jury service. And you've got the United States Supreme Court saying, you know, we're not taking cert. So that thin kind of understanding is what emerged after that in terms of the scope of women's citizenship. So they had the vote, but couldn't serve on juries in many cases until well into the 1940s, 50s, 60s. Same thing with public office. It was a patchwork of legislation that, again, you know, sort of explains that. And so I think that failure on Alice Paul's part to heed the call of, again, the African-American suffragists who said, come help us in the South, use your resources, join with us, was in large part just in a pivotal moment for the power, whether you would amp up the power of that 19th Amendment. And then finally, you mentioned the constitutional definition of equality. And again, I'm happy to talk more about all of this in our questions and question and answer. But, you know, the constitutional definition of equality, there were what I have labeled the neutrality feminists who were just interested in a non-discrimination approach to equality. They didn't want class legislation that treated men and women differently. Then there were other, right, and we call them social feminists after 1920, after ratification, who had worked very hard. Florence Kelley was among these who worked on Muller versus Oregon to get special legislation that protected women from excessive hours of work and provided a minimum wage for them. And so once Alice Paul gets that 19th over the finish line, she turns immediately to the Equal Rights Amendment. And I would argue too quickly. Had she joined African-American feminists and worked to bring cases, right, against voter suppression in the South, courts would have had a chance to flesh out the power of the 19th and the scope of the 19th. But she didn't do that. And so this Equal Rights Amendment battle begins and you see splits. And so the methodology of my book is to look at the fact that suffragists as actors, institutional actors within civil society had pushed that amendment and played a pivotal role. And I look at Congress and the courts, but really the focus is on suffragists. They back off that. And when you take your foot off the accelerator, as a lot of scholars have sort of noted in the development of law, courts tend to regress. They tend to, the development of the law tends to slow. And so I look at that sort of backing away. And then I also look at the splits in the movement. Again, a very important thing to sort of look at and historically in the development of law is what are the splits in these movements? And that split over what equality meant. Did it mean simple neutrality, anti-discrimination, or did it mean an anti-subordination norm where affirmative acts were necessary to put women in a different position because they were starting from behind, right, the starting line? That fight just essentially eviscerated the battle for the ERA. And we still don't have it, right? And so that's another interesting, I think, story about the implications. And again, that's class. So we have race and gender and class and basic federalism questions, right? And the scope of women's citizenship, and then, of course, the definition of equality.
Fantastic, thank you. So both of you have presented us with these very rich and complex histories that are entwined in multiple ways at the intersection of race, gender, and class. And I think in the book, Professor Monopoli, you refer to this as a multi-institutional puzzle. So what I'd like to do is open up our conversation a bit and ask you to engage in conversation around a couple of questions, and then we can turn to questions from the participants on the call. So if you do have questions, please do put them in the chat. I'll be gathering them. But I guess I want to return to the first question with which we began, which is given all of these factors and events and actors operating across time in the way you both described, in your own thinking and in your scholarship, are you in agreement that this is a puzzle? And if so, what is the source of this puzzle, or what is the answer to the puzzle in a sense? about why the 19th has become a constitutional orphan. So maybe I could ask Paula if you could start.
Sure. So, you know, the reason I sort of thought about constitutional orphan as a title is, you know, I wanted again to focus on the role of the suffragists in that institutional, as institutional actors in that story, right? And again, it's multi-institutional, and we cannot say that the suffragists and backing away, which is one kind of concept behind the title constitutional orphan. It's that the people who were the proponents moved too quickly to other things and moved too quickly to things like the ERA without kind of nurturing. Amendments need nurturing. They need legislation. They need court decisions to amp them up. And that's kind of tied to the second idea that I had in naming the book Constitutional Orphan, and that is that the 19th simply, right, became rarely cited by courts. So for example, the 19th is cited over just a little over 600 times, right, after 1920 to the current day. And the 15th is cited at least 4 times as many, close to 5 times as many. I think there's been 2,800 plus citations of the 15th Amendment, most of which, 2,700 of which are since 1920, if you're measuring from 1920. So it became a constitutional orphan that way, rarely used by courts to analyze other constitutional doctrines. We had a blip in 1923 with the Adkins case where the court sort of raised the 19th Amendment and said, oh, because the 19th, you know, we're essentially going to change rules about the Fifth Amendment. But besides that, they rarely sort of invoked it. And there's actually one case, and it's a case that actually dealt with poll taxes, where the court actually addressed whether or not a state statute violated the 19th Amendment, right? That's Breedlove versus Suttle. So it's not a heavily used amendment. It just sort of disappeared from our collective memory. And that's why I think it's so important. And so in terms of the question of the puzzle, you know, I would suggest to you that one of the reasons was because those proponents split afterwards. They turned their attention to other, and they did wonderful things. They worked in the state chapters, worked in state legislation. They got a lot of positive change for women, laws struck down, laws changed. I don't mean to blame them for this, but the fact that they were the major kinds of proponents of this federal amendment and then took their foot off the gas, if you will, I think helps us understand the puzzle. And then of course, I think there's the intersection of race with this question, which is they missed that moment. That allyship, that solidarity it was a moral failure, but it was also a strategic failure. That strategy of appeasement of white Southern congressmen, and Alice Paul needed votes for her new amendment, never works, right? A strategy of incrementalism and appeasement gives you a weak amendment. It gives you a weak sort of law in that regard. So I don't know.
I would also
Professor
argue
Banks.
that the difference between the 15th Amendment and the 19th Amendment is that you had people from within Congress pushing to ensure protection, and you didn't have that same kind of push with the 19th Amendment. And you also had sort of this not incredible, but you had sexism, which operated. I mean, many members of Congress said, oh, well, women aren't, if we give them the vote, they aren't going to vote, or they're going to vote like their husbands vote. And for others, especially in states where you had growing numbers of Black and immigrants who were eligible to vote, there was the feeling that white women could be used to offset the vote by these other people. And so there were no cheerleaders. And once the external cheerleaders left and denied a voice to the Black women, to me, it's actually not much of a puzzle if you take a very cynical view of it.
Terrific. So if we think about the long history of these struggles and the different movements that were involved, and I'm echoing here a question in the chat from David Cade, what lessons do you think we might learn about what we mean by equality under the Constitution today, particularly on issues around race and gender? Both of your scholarship is so grounded in questions of equality jurisprudence. What are the lessons that we should take from these famous?
Can I just say that, I mean, one of the things that you have to go back to the abolitionist movement, because the big question was, what is, you know, once you have enslaved people, and once formerly enslaved people were free, what does freedom mean? And for I think for the abolitionists, and I would argue for most Black Americans today, freedom means equality. And what is the measure of equality? And that's equal political rights. That's equal access to the vote, equal access to actually the jury, because we're still fighting the jury with Batson challenges, and equal access to the ballot. And we still don't have that. And one of the things that I think is very important to point out is that the 14th Amendment, well, the 15th Amendment wasn't ratified in the state of Maryland until after the passage of the 1965 Voting Rights Act. Maryland, Kentucky, California were late ratifiers. And so there's been real resistance to political rights for Black men and women. And I would say for non-white men and women.
And I would echo that. I think in terms of the history, again, immediately following the ratification of the 19th, those suffragists like Florence Kelley, and I come back to her because, again, she was both a member of the National Women's Party, but she was a co-founder of the NAACP, and she was the president of the National Consumers League. So this is a woman who was a legal progressive who said in the meeting of the National Women's Party, where they met to decide, well, what's our next task? Should we disband now that we have the federal amendment, or should we do something else? And they decided to push forward with the Equal Rights Amendment. But she said, in terms of that protective legislation for women, what good is equality, right, if you're not operating under equal conditions? And, you know, this is, I think, a critical piece of the discussion that we're having today. Right? If women as a class are subordinated, and I would argue that we still are in many ways, right? And especially women of color, then what does it mean to talk about equality, right? From that perspective. And our Constitution has tended to be a negative rights Constitution, right? Not a positive rights Constitution. And that's what people like Florence Kelley were getting at, right? How much affirmative, positive action are you going to authorize under this Constitution? And again, I remind everybody the 19th, right, is essentially, as was the 15th, the first section was a prohibition or a check on government power. The second happened to be a grant of power to Congress to step in, right? But again, we tend to look at this in a sort of a negative rights format. And so that's the battle today. When you have issues like pregnancy, you know, how do we work with an issue like pregnancy, the Pregnancy Fairness Act, for example, when you've got differences between men and women? And neutrality, where you've just got rules that are exactly the same, doesn't help us, you know, sort of analyze what that means. What does equality mean for those right issues? And so we're still fighting this. And again, the Equal Rights Amendment is tied up in the courts, and its ratification is, who knows, right? It might be a year, it might be two, we hear about the deadline. But the 19th, we've got the 19th. So to the degree that we can make it more robust, that we can use it today to advance equality in a variety of areas, I think that's a really a sort of an interesting and exciting proposition.
Fantastic. So, I mean, Professor Monopoli, you mentioned earlier this tension between what you called neutrality feminists and social feminists. So I have a question, I guess, for both of you, which is, to what extent do these histories inform that debate today in both legal thinking, but also in cases that are arising in the courts? Are we seeing an attempt to understand this history in a way that can contextualize some of the problems with neutrality feminism? Yeah.
Well,
thanks.
okay. I would say, just sort of offhand, I mean, that there's certainly division persists even within the feminist movement between those who believe in formal equality and those that believe in substantive equality. And I think Professor Monopoli is talking about, and I think when you look at some of the early ideas of the women's movement going back to the mid 19th century, women were talking about, I mean, one of the things that always gets me is that the women during that era were saying, we not only want the vote, but we want to have pensions because we work at home and we need to not be financially dependent upon our husbands for financial support when we're old. And they were talking about social rights and issues that were in some ways unique to women. And so I think that this battle still, this tension still exists. But Professor Monopoli, go on.
Yeah, I completely agree. And I think when we see this history, again, from the earliest kinds of conventions in the 19th century, you know, what their demands were very broad, as Professor Banks says. And then we narrowed into the vote by the late 19th century, in part, I think, because to get any sort of movement going, you had to sort of have, you know, a single issue to get this, you know, diverse group of women who had lots of different interests, lots of different classes, right? And so, you know, we lost something with that narrowing. And I think it took the whole 20th century to sort of reopen then and make it a wider lens in terms of what we're looking for. And so I do think that that was a lesson that we can learn, right? Was that the people who sort of won out after the 1920, you know, that decade of contested interpretation were the neutrality feminists in a lot of ways, right? And so, you know, protective legislation eventually gets struck down. We get back to that formal equality sort of paradigm. And so, you know, I can't say that today we have moved beyond that, but I certainly think that the theorizing around cases that are brought today, especially in terms of intersectionality, right? So there's a lot of really important scholarship that informs us in cases like Title VII, for example, right? About the fact that we need to reform these statutes and our tools to acknowledge that there's a different intersectional claim, for example, if you are disadvantaged by both race, right, and gender. It's not just simply a case under Title VII based on race, a Title VII based on sex, that's a different qualitative sort of discrimination. So I do think that it's certainly in there. But again, the history of the 20th century, you know, we had wonderful theorizing by people like Pauli Murray, right, who sort of analogized to Jim Crow. And then obviously Ruth Bader Ginsburg building on that using the 14th Amendment. And so, you know, hopefully we kind of add that positive rights, again, you know, sort of substantive equality piece to the analysis as we move on. But it's very slow. Our traditions don't really embrace that approach.
Well, I mean, but I would add, I mean, I keep going back to Franklin Delano Roosevelt, who in his, I think, 1944 inaugural address, introduced what he called the Second Bill of Rights, which were in point of fact affirmative rights, which, you know, just sort of got lost, you know, and would have been the other part of his social progressive program. And, you know, there've been attempts, again, to sort of talk about affirmative rights, but we see them primarily in other countries like South Africa and the Eastern European countries that have much more modern constitutions than we have. And Ruth Bader Ginsburg talks, you know, positively about affirmative rights, but, you know, it's not getting much traction.
Mm-hmm. It's quite fascinating. So, you know, as a pure matter of constitutional history, if we could go back in time, you know, what do you think would have happened if the suffragist movements, as key players and social movements in civil society, had not so quickly turned their attention elsewhere to a new amendment? I mean, what do you think might have happened?
Well, I think that one of the, I don't do much analysis like that in the book, but if I were to speculate, one of the interesting pictures that I would paint are people who were like, again, I go back to Florence Kelley because she was a veteran litigator. Alice Paul was a lawyer, but she was a fairly newly minted lawyer, actually getting her degrees after the 19th Amendment was ratified. But people like Florence Kelley had been in the trenches in cases like Muller versus Oregon. They had made law right? And I think of people like Thurgood Marshall, people like Ruth Bader Ginsburg, right, who are pushing that law, who are doing test cases. And I would like to think that if they had heeded the call of African-American suffragists to engage in the South for, at least the couple of years after the 19th Amendment, before turning all their resources and energy to Equal Rights Amendment, for example, that there could have been cases that bubbled up that gave us a deeper understanding, right, of what the 19th Amendment meant. And I'd say the same thing with enforcement legislation. If they had not turned away from enforcement legislation, for example, the National Women's Party, and had supported it and not quietly withdrawn their support because they were then strategically needing the Southern congressional votes for their new amendment, enforcement legislation is important operationally, right? It was after the 15th Amendment, and in terms of putting people on trial who denied people the right to register and the right to vote, but it also has an expressive dimension. It tells us that Congress is taking a central role in this, right? And that complete absence, I think, again, really undermined the power of the 19th as far as state courts. You're signaling to state courts, this matters, right? And it provides a platform to get cases from state courts up into federal courts, which didn't happen. So I'd like to think that if they had worked and had heeded that call and had gone in and litigated cases and pushed enforcement legislation through Congress. Now, they pushed the enforcement clause through Congress. They got pushback. Professor Banks mentioned that there was an attempt to put an amendment in that limited the vote to white women, limited the amendment to white women. They also pushed back on the enforcement clause itself, but the proponents of the 19th prevailed on that. So, yes, they would have gotten pushback on the enforcement legislation had they really put all their resources behind it. And, Southern congressmen would have resisted, I'm sure, again, sort of raising the specter of a second Reconstruction was their favorite kind of way of pushing back. But, the suffragists had gotten that 19th and they'd gotten the enforcement clause in the 19th. And so, it is possible that they could have gotten some substantive enforcement legislation through.
I would go even a step further. If in fact there had been a real coalition, even among the women in the North, you could have gotten things like anti-lynching legislation that Ida B. Wells advocated, because it wasn't simply Black men who were being lynched, women were being lynched, and even children were being lynched. You could have gotten, if you look at what the Reconstruction Congress in South Carolina did during the brief period it was in office, it created public schools, it created a lot of social welfare legislation that women, I think the women outside the formal feminist would have supported. And I think we would have gotten a lot of the social legislation, some of which comes in the late 30s, and in the 50s and the 60s, much earlier, and the quality of life would have improved. And it might have also shortened the length of the Jim Crow era.
Mm-hmm. So I have a couple of questions in the chat that really I think I can ask together, and they really relate to what the relevance of the 19th Amendment is today. So Lydia Gines asks, how do we ensure that the social issues we face today, such as domestic violence and maternal mortality, how do we ensure we don't fall into the same traps as occurred historically, and how do we keep these kinds of movements intersectional? And Max Phillips asks in a related way, what are some examples of legal questions or justiciable issues that could be presented today in the courts that could be examined to create a more robust constitutional meaning to the 19th Amendment?
Well, I think if it's okay, that I'll just start with the current movement today in terms of state statutes, which many of us would characterize as voter suppression, is just an opportune moment to reinvigorate the 19th Amendment and to use it to suggest, right, that some of those statutes, voter ID laws, early voting, restricting early voting, for example, and things, statutes which require fees and fines to be paid before one is reenfranchised, all have a disparate impact on women. And again, I'm happy to talk more about that and why that is, but it has to do with the gender gap and our disproportionate childcare responsibilities and issues like that. And so there is room there to, again, not likely in the near future, but to work on enforcing the 19th, getting legislation through, which would actually give the 19th some teeth and help us combat those kind of state statutes, which I think are going to be with us for a long time. And so I do think that those are areas where we can work together, where we can sort of focus on solidarity and focus on being allies. And it's that, when I keep thinking back to that exact moment when white suffrage leaders turned away, right, from African-American suffragists and said, that's about, your issues are about race, ours are about sex, right? We now know that that's, right, an illusory sort of distinction. And so in voter suppression today, now that's a kind of a narrow, if you read the 19th Amendment in the light of all the other voting amendments, our trend has been to expand the polity, right? So that's one way, I think, where we could really almost redeem the legacy of the 19th and the racism that was in that movement around the 19th, to use it for those purposes. And again, intersectional claims that we could get sort of through legislation, authorization for intersectional claims. And I think that's an important place to work.
Professor Banks?
Oh, I'm not as hopeful. I mean, I think Professor Monopoli is right. I think those things the amendment could be used that way. I'm not sure that there is the will. One of the problems with coalitions, especially coalitions across racial lines, is that they are short term. They usually work best when the interest of both parties converge. I'm not convinced that enough white women believe that their interest, their voting interest converges with that of non-white women. And so I'm not sure that they would join in large numbers an effort to try and expand the scope of the 19th Amendment.
Mm-hmm. Okay. We have a question here that I must say, as a human rights lawyer, I heartily think is very interesting, which is what would happen if the United States finally ratified CEDAW? And I would add, finally ratified the Covenant on Economic, Social, and Cultural Rights, which I think Professor Banks was alluding to earlier. So what if we thought about these questions, not just as constitutional questions, but also as human rights questions in the United States today?
Well, can we get the Supreme Court to actually cite to these things approvingly?
Well, of course, getting ratified would be the first step, yeah. Professor Monopoli, any thoughts on CEDAW?
Yeah, I do think that clearly that would be a step forward. And in that international framework, right, again, the expressive dimension of ratification is really important. I mean, in addition to the sort of the legal implications of being able to rely on it. So I think that would clearly be a step forward. I think there's also a movement, and we've seen this, again, recently, but we've seen it in the past, to think about how we can create an affirmative amendment that gives people the right to vote, right? So, you say to your students, did you know that there is no right to vote in the Constitution, right? And they say, what? And most Americans, right, don't understand that. So the notion that you could amend, and again, the amendment process under Article 5 is very difficult, takes a long time, but these suffragists worked without the vote. They used every political sort of tool available to them. They assembled, they protested, they were arrested, they were jailed, right? And it's remarkable that, not having the vote, they were still able to create this important shift in federal state power, if you will, by passing this, getting this federal amendment passed. And, women of color who were suffragists at the time did that with structural racism, right, as a burden on them. And they all did this in a pandemic. So it's really still, I think, perhaps I'm more hopeful than Professor Banks this way, that if you can move that coalition and you could get some affirmative right to vote, for example, that might move the needle as well, in addition to ratifying CEDAW and international conventions.
Right. So, Professor Banks, I know in your scholarship you addressed this point, maybe just for the students particularly. Why is there no right to vote in the federal constitution?
Well, I mean, I have a very cynical answer. That's because the founding fathers never intended to create a democracy. They intended to create a republic. And if, you know, and that's explained by, you know, if you have any doubts, look at the fact that we did not elect members of the Senate by popular vote until the beginning of the 20th century. And the franchise was really limited for a long time to people who own property. I mean, I'm not talking about property involving poll tax. I'm talking about serious property. And so as we have become more democratic by extending the franchise, you know, I argue somewhat cynically, very cynically, that the meaning of citizenship has become less vibrant than it was certainly in the beginning of the 19th century. And that's why you hear calls today about rethinking what birthright citizenship means. That's why you have the government today sort of seeking out people who they claim have misled people on their naturalization forms. And so I would argue there's a real attack on citizenship today that is directly related to the broadening of the franchise and to protective legislation like the Voting Rights Act, which has been eviscerated by the Supreme Court.
Oh, that's fascinating. Well, we're almost out of time, but I have one last question for Professor Monopoli. First of all, congratulations on this book. It's a really fantastic publication, I think, and I've learned a lot reading it. First of all, what was your inspiration for the book, and what reactions have you had since it was published?
So my inspiration for the book was a series of articles close to 20 years ago now, which suggested that the history of the 19th had, again, sort of been forgotten to our collective memory, and that the 19th could be read together with the 14th Amendment to shape and affect other constitutional doctrines. So, for example, give the federal government the power to step in and create private remedies for domestic violence when the court has said, well, those are issues of the states. You know, the federal government should not sort of be intruding in there. And that was a really interesting idea. So that was kind of the inspiration. And then the historical aspects of it. I knew that the centennial was coming up. I was very curious, right, about how that kind of loss to our collective consciousness had come about. And I wanted to kind of affirm for myself through historical research. And I spent a lot of time in different archives, Library of Congress and Schlesinger Library, which has a wonderful women's archive, and read what these women thought the amendment meant. And there's a wide variety of decisions. But as Professor Banks said, at least it was political liberty, meaning broad, expansive political liberty. And that was that became pretty clear. So, so the reaction, you know, so far, the book just came out, the hardcover just came out this week. So it hasn't been widely circulated, but the people who looked at it and did some very nice blurbs on the back cover, all I think thought that it added it surfaced some history, especially around the lack of enforcement legislation and the central role of race in that piece of the story. Yes. That helped us explain how it became this kind of very thin understanding that emerged from the decade after. So that's been gratifying.
Fantastic. Well, thank you both. I think this conversation has really proved, if we needed any proof, that legal history really is critical. And it is not really about the past. It's always about how it informs the present. And this has been an extremely rich conversation. So virtually, we'd like to thank both Professors Banks and Monopoli for this conversation today. Thank you, everybody.